Hello friends, what is the policy of the Honorable Supreme Court of India when it comes to the accused or criminals who have committed who are facing allegations that they have committed certain crimes and they are facing trials in the courts below, and they have gone for bail applications to the Honorable Supreme Court, or they have taken the quashing pleas which are dismissed by the High Courts, which have gone to the Supreme Court in the form of SLP. So what is the stand of the Supreme Court? So let me be very clear, friends. The stand of the Supreme Court, Honorable Supreme Court of India, when it comes to the accused or even to that matter of any court, is to inflict punishment to the accused. It's not that prima facie no court will believe that the person is innocent. So normally in criminal law, in criminal jurisprudence, it is a known theory that a person is guilty unless and a person is innocent unless and until he is proven guilty. So in this, but the same is not applicable most of the times. What I have noticed in the Honorable Supreme Court as well as the High Courts is, when you go for quashing, they will not entertain your plea so easily. First of all, the section 482 CRPC, that is called Criminal Procedure Code, which is the inherent power of the High Court to quash the FIRs or charge sheets. It is rarely used, in the rarest of the rare cases, not in every case. Let's say 1 in 10,000 FIRs gets quashed, and 1 in 1,000 or 500 charge sheets do get quashed, if at all there is no legally adducible evidence. So when you go to the Supreme Court of India, if the High Court dismisses your quash petition, Supreme Court will also not entertain whether it's your bail plea or else your quash plea so easily. If you are convicted, then they will take it seriously and they will examine all probabilities, but not before that. So one has to understand, clearly understand that the policy of the Supreme Court is, it's retribution. It is called retribution in legal terminology. That means inflicting punishment to the wrongdoers. That is bringing perpetrators of crime to the book and punishing them. That is very, very important need of the hour. This is what the Supreme Court believes in. If you are thinking that bail is a rule and jail is exception, you are thoroughly mistaken. That can be used at the discretion of only the judicial officer. That is not law created by the Supreme Court. It is just a legal maxim. Alright, nobody can dwell on it. So many times the Supreme Court has said bail is a rule and jail is exception. But it has also said that the perpetrators of crime has to be punished. So always the Supreme Court speaks with two tongues. So two versions. So one needs to understand that everything will be based on the facts and circumstances of each case. So what you need to understand